Good grief, I just wrote 2023.
I was right.
2028? Good grief. At least I'm making us younger, not older. What is this? Hers.
I'm gonna take care of it, Mr. Mayor.
All right, ma'am, good morning. Are you Melissa Taylor?
Yes, ma'am.
And will your client waive the formal reading of the indictment in each case?
So waived.
I'm going to take judicial notice of the court's file. Ms. Taylor was evaluated for competency to stand trial. Dr. Krapon did that evaluation. I've received the report dated May 22nd of 2025 with the finding from Dr. Krapon that Ms. Taylor is currently competent to stand trial. Is there any other evidence with regard to competency?
Your Honor, I can only say that I've visited with her a couple of times out at the jail and again this morning, and I believe that she's mentally competent.
All right.
I can't say that there's no evidence of mental incompetency because I think that there was at one time the evidence, but there's been none that I've observed that would lead me to think that she's currently mentally incompetent.
All right. And Mr. Nichols?
Nothing to add, Your Honor.
All right, then, based on the report and Mr. Kimler's comments, I am going to find Ms. Taylor currently competent to stand trial. Now, Ms. Taylor, in cause number 24 DCCR 2177, you're charged with second-degree felony offense of assault on a peace officer from October 2nd of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
That would be correct, yes.
All right, and in cause number 24, DCCR 2311, you're charged with the state jail felony offense of credit or debit card abuse from October 2nd of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
I did.
Do you fully understand them?
Yes, ma'am, I do.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a cap of 5 years in the assault on a peace officer case. And then whatever happens, I guess you're pleading open on the other one as long as I run them
I made a
concurrently.
recommendation for 12 months on that
Okay,
case, Your Honor, and the defense had made a recommendation for probation concurrent with that.
Okay, so in essence, a cap of 12 months then? Would
Yes,
that,
Your Honor, that's fair to say.
A concurrent.
with everyone's permission,
Yes,
can I make that? Let's see. Cap. So it would be a cap of 12 months on that state jail case. Do you understand?
Yes, ma'am. And that's for the
No,
No, it's for a credit card.
credit card.
So what that means is that if we go forward this way, you're leaving your punishment up to me.
Okay.
And as long as I don't give you more than 5 years in the assault on a peace officer case and 12 months on the credit debit card abuse case, then you're waiving your right to appeal. I can give you 5 years, I can give you less. It'll all be determined when I get the information at a sentencing hearing. You have an absolute right to have a jury come in and determine 2 things. The first would be to decide if you're guilty or not. And then if they find you guilty, you could leave your punishment up to them. If we go forward this way, you're waiving that right and leaving it up to me with those ranges that you've agreed to. Is that what you want to do?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1 in each case.
Without objection.
It's admitted in each case. All right, ma'am, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Again, find that you're mentally competent and understand the nature and the consequences of your pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases so that the probation department can do a pre-sentence report. That'll give me more information about you, your cases, and then we will cut back later for sentencing. Anything that you think is important for me to know, be sure and get that information to Mr. Kimler. He'll present it to me on your behalf when we come back. All right?
I do have a support letter that I tendered to the court.
If you'll just get that to the clerk, please. All right. Thank you, ma'am. You can go back with the bailiff. That's exactly when both of y'all do that. When she does it, I think of that all the time. All right, sir, you said Dog Wilson? Ma'am, I'm sorry. I was looking at the down this way and not at you.
Seidel Wilson.
Seidel?
Yes, ma'am.
Okay. And Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your Honor.
Let's see.
Even judges have those oops moments, but see how she flips it with humor that's leadership wrapped in grace. A quick laugh resets the tension before the courtroom gets heavy.
I'm getting there. All right, Ms. Wilson, in cause number 22-40450, I have a first amended motion to revoke your unadjudicated probation. This shows that you were placed on probation February 27th of 2024 for the offense of burglary of a habitation, and that was a 5-year deferred probation. Is that correct?
Yes, Your Honor.
And then it alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department March 14th, March 26th, April 9th, April 23rd, May 8th, and May 22nd, June 4th, and June 18th of 2024. And is that true or not true?
Yes, Your Honor.
Is it true? Okay. Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true?
Yes, Your Honor.
Judge, since we have an agreement.
Listen, now, hold on.
I'm sorry.
Thank you.
Since we have an agreement, we can drop 3, 4, 5, and 6 and just go to 7, if that's all right with the court.
Count 7 alleges that you were arrested for the offense of failure to identify a fugitive from justice and giving false information April 14th of 2025. And is that true or not true?
True.
Count 8 alleges that you were arrested for possession of drug paraphernalia April 14th of 2025. And is that true or not true?
True.
And then count 9 alleges that you were at a location other than your residence at approximately 12:32 a.m. April 14th of 2025. And is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, 7, 8, and 9 freely and voluntarily?
True.
Were they volunteer?
Volunteer.
And did you, it's okay.
Yes, Your Honor.
It's all right.
Sorry.
You're good.
Thank you.
Did you enter those pleas of true freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true?
Yes, Your Honor.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, Your Honor.
And do you fully understand them?
Yes, Your Honor.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Wilson is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1, 2, 7, 8, and 9 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty.
Competency check major turning point. The court can't move forward unless the defendant fully understands the process. Without that competent to stand trial stamp, this whole case hits pause.
Of burglary of a habitation. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody, but the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas.
Yes, Your Honor.
Good luck to you, ma'am.
Thank you.
Okay. Good morning. Are you Stephanie Moore? And Ms. Moore is on probation for robbery. There's a motion to revoke, and what's the...
Judge, Miss Moore's been absconded for 7 years, and she's not been picked up. I almost just don't really know how to proceed because we have no idea what's been going on with her for 7 years. I'd like her to have an opportunity, if she chooses to tell the court what she's been doing before we really make a recommendation here. Obviously, she can choose not to, but...
Mr. Rojas?
Judge, I've spoken with Ms. Moore. She's told me what has been going on for the last 7 years. I mean, she would like to tell the court where she's been, how her life has been going on. Ms. Moore?
I've been in a bad domestic relationship and was not allowed to pretty much do anything. Put up a mailbox, don't get any kind of medical help, get an ID. When I got strong enough to leave that relationship, I put up a mailbox, got some health insurance, and realized that I needed to get my driver's license back and be, I have to take care of my past, and this was my past, and he wouldn't let me do that. I asked him over and over again to help me, support me behind this, or come at least drop me off at the jail so I could take care of this, and he, just the way we lived and the way he lived, it just wasn't something that was able to do. When I did try to leave and kill my cats, and pulled me back to the house, I broke my wrist this last time, and I just fled to the cops and screamed out of the neighborhood, and the cops came and I ran to them and just said I need help. And so I knew this was here, and I knew that I have to take care of whatever I needed to do to put this behind me, so that I want to live a normal life and have my license and go get a job and have a home and a mortgage and land. And I'm 48 years old, about to be 48 years old, and I just want to get my life back without that.
So, I mean...
She was ordered to safety back in 2018 and did not report.
No, I went to safety. I've done safety.
In 2018?
No, I did it when I first got...
She just pleaded guilty to assaulting a peace officer. That's a serious felony. We're talking up to 10 years behind bars in Texas. Watch how the judge boxes this deal into strict limits.
She was ordered back in 2018, after I think having done it around 2012.
Okay.
They haven't heard or seen from her since, so.
Hold on. So here's what I would say. We do, the only thing I would know to do is go through the motion, get an updated report that would include substance abuse assessment, where we are now, more information about all of that, and then we can see what our options are. I mean, the motion has been holding it open, and so I can... What can I do from 2011?
Classic courtroom gamble. She's trading a jury's uncertainty for a guaranteed cap. But here's the catch: once that gavel drops, her right to appeal is gone forever.